Welcome, everybody. Before we get started, want to read a quick disclosure for everybody, a little bit different on this one. This presentation is not intended to serve as a substitute for personalized investment advice from MCF Advisors LLC or personalized legal advice from MCF Legal PLLC. You'll learn about who that is in just a second. To the extent that you have questions pertaining to the suitability of any specific strategy for you and your individual situation, you are encouraged to consult with the professional of your choosing. A copy of MCF's current written disclosure statement and customer relationship summary, which is known as Form CRS, which is discussing our advisory services and fees, continues to remain available upon request. So got that out of the way. So really special guest today, Ramsey Watson. Ramsey joined our firm, is it October now?
It is.
Yeah, October. So she joined in a couple of different capacities, but first a little bit about her. She's a graduate of Western Kentucky University. She had a double major because, one's not enough, in psychology and political science. In 2012, man, I'm old. She obtained a Juris Doctorate from the University of South Carolina School of Law. She's been practicing as an estate attorney for over a decade now, I believe it is. Ramsey is focused exclusively on estate planning, probate and trust administration, and asset protection. She joined the MCF team in October, as I mentioned, as a wealth transfer advisor, while simultaneously launching her own law practice here, and it is known as MCF Legal. Ramsey, I hope that was justice enough for how brilliant you are. Thank you for doing this. I really appreciate it.
Thank you, Hunter. I'm thrilled to be a part of it.
Good deal. Okay, so a couple of things, guys. So estate planning, if you don't really know what that involves, I kind of like to set the stage a little bit. The estate planning is the process that involves in preparation and management of tasks related to either incapacitation and death. This includes the transfer of assets and things like maybe guardianship of your children and end-of-life decisions and care. So in a previous life, you might have heard talking to other advisors or state attorneys, it really does come down to kind of like two different phases. There is things that you need to have in place before you pass away, and then things that are recommended after you pass away. And there are a lot of different documents that can be involved in either one of those situations, but they are both important. Most people conceptualize that estate planning is just when you die, and that is just not the truth. So it's very important. I think you all will walk away with a really good foundation of those things. But let's get started. So Ramsey, I just stole a little bit of your thunder, but why don't you tell me a little bit why estate planning is important?
This is a great question, and because a lot of people haven't thought about it, or if they thought about it, it's just been casually over life events. But everybody needs an estate plan. Everybody has stuff, whether it's personal property, family members that they need to take care of or that they want to include in their wishes. Everybody needs a plan. And if you don't have one, the state has one for you. And so you want to make sure that you at least know what the state plan is if you haven't done an estate plan of your own. It helps protect the people that you love, and it helps minimize your costs and fees that your loved ones and or your stuff will be subject to, either during life or after you pass. And it also helps you avoid paying taxes that you don't need to pay.
Yeah, that's a great summation of it. Let's start with this. What is the process legally? You can name it. I won't spoil that for you, but what is the legal process involved once someone dies?
So the process that your estate goes through is called probate. And the Latin word for that is to prove. And it's to prove your wishes and or what should happen with your stuff. So if you have estate planning in place, that's called testate probate, meaning there is a document that they can look at and it says what you wanted to have happen. If you do not have an estate plan in place, it's called intestate probate. And it just means that they're going to follow what the statutory law is in the state where you reside when you pass.
That's great. Now, we have a lot of people on the call today, and we'll have even more that watch this on replay. Obviously, with as many as 2,000 people in this program that are enrolled, it's always changes year to year about how many people we have enrolling in this. But we cover about 9 to 10 states. It's growing because some of the businesses and companies that we serve on the retirement plan side are continuing to grow outside their bounds. So it definitely is different. But estate laws, if I'm not mistaken, are state specific, correct? But is there any commonality amongst them? I would say in terms of basics. Obviously, there's nuances, and so that's why it's important to contact people in that state. But how do you feel about that?
That is a great question. So I actually am in the process of trying to get as many states as I can. Right now, I'm licensed in 3 and working on my 4th right now, and it is very nuanced. So across the states, you will see differences in things like taxes. Like here in Kentucky, we have what's called an inheritance tax, but we're one of only 6 jurisdictions that has that. Some states, especially in the New England area, they have a estate tax that is different from the federal estate tax. So it's really important that you work with and or at least seek the guidance of somebody who is licensed in your state because those rules do vary. In so much as how much you can pass away with and not have to go through a full-blown probate. It varies from state to state. I think in Indiana it's 100,000 and here in Kentucky it's 30. So just important things to know that can vary. Throughout the states, though, there are some really common themes or threads that you'll see in probate law. And that's because we have taken probate law from England and we've brought it over and we've made some couple tweaks here and there, but at its core, it's really the same. It's heirship and how assets go from one generation to the next. So you'll see things like intestate probate. You typically are going to have the same people listed. Now, those percentages will vary from state to state. In some states, you'll have your spouse and your children will both inherit assets at the same time if you don't have an estate plan in place. And for most clients, that's not what they want. They want their spouse to have it and then pass down to the kids. So there are definitely some common threads in there. You'll see things like revocable living trusts. They're included in all 50 states. You have a uniform trust code and a uniform probate code. Not all states have adopted both, but they are the foundation and the model for all state statutory law.
Awesome. That's fantastic. As I mentioned before, at least when I'm explaining just the basics to both participants and clients alike, you break this down really into 2 categories. And as my dad used to say, you have a above the ground planning. So it's things that you have in place that you need to have while you're still living. And those vary in various needs in terms of those things. We'll get to that in a second. And then below the ground planning, which is fairly self-explanatory. So let's talk about the basic documents and what's really basically needed, at the minimum in your expert opinion, and really other things that can, be done to properly prepare from an estate planning perspective.
Absolutely. And I love that your dad knew those 2 things because I see a lot of clients who totally forget, and you mentioned it earlier, totally forget the above ground planning.
Yeah.
And I have clients who walk in and they're like, I have been through probate and they're talking about a parent or a family member, and they're like, I don't ever want to go through that. Their biggest concerns are what happens when I die. And I tell clients, my biggest concern isn't what happens when you die. You're not going to be here anymore.
Yeah.
My biggest concern is what happens if an elephant falls from the sky and hits you on the head. You don't know who you are, but you don't pass away. Who's going to take care of you?
Yeah.
And a lot of clients don't think through that, even though we're all kind of aware of it. There are steps that you can take to get a plan in place so that that is not as problematic as it can be. Things like a general durable power of attorney. That is a really important document. It's a very powerful document. It's a document that allows somebody to act on your behalf while you're alive. It loses all of its credibility when you pass, but it helps when you are here, but you need somebody else to do things for you, like a parent who has a child on their checking account. It's helpful if you have that power of attorney capacity so that you're not necessarily making your child an owner of your account. They just can help sign on stuff. They can talk to the IRS on your behalf. You may not want to have to deal with your tax returns in your later life. And so that lets somebody else act on your behalf when you're dealing with Social Security, IRS, things like that. Also, retirement accounts. That's a big one. So your retirement account, you have to own in your name until you pass away. And the only decision-making capability that somebody else can have on those other than you is a power of attorney. And so we really, if you have an IRA, you need to have a power of attorney in place. Things like your healthcare directives. Those obviously become a moot point when you pass. So we want to make sure that we have them during life so that you have somebody who can make medical decisions on your behalf when you're unable to do so, and that somebody else can get medical information about you. So your HIPAA authorizations. Usually you fill those out whenever you check into the hospital, if you're able to, or at your doctor's office. Sometimes they have those in your initial forms. But those are all really important in life planning opportunities. And those are the bare minimum basics that I recommend everybody have.
You know,
When
my mom last week had her knee replaced. And one of the things when you check in, we got there, I think it was 4:30 in the morning. And that's one of the things they said, do you have an advanced directive? And, can you provide that for us? And
Yes.
so, and I was like, well, I don't have it with me, but I can email it. And they said, well, we can take it by email. That's fine too. So before we move on to the next, like the more of the below ground stuff, I want to circle back on the power of attorney. Um, so this is mostly in place in the event of like mental, not necessarily, I mean, I know that's broad. There's a lot of, you can be very specific, but really in the event of incapacitation. So, I've seen it in an actual process with clients before, um, in the event of like a stroke. I had a client that had a stroke. And they didn't have that. They were in the middle of kind of getting that done, but they put all of this stuff off. And correct me if I'm wrong, here in Kentucky, because they didn't have it and they wanted the wife to be able to make some of those decisions because the client was non-communicative at that time and probably would be for a while, end up being about a month and a half, 2 months. And there's things that needed to be done inside the business, but they had to petition the court for an emergency order of guardianship. Is that the correct
That is.
process?
Yes. So that's a great point. So absent having a valid document that is going to be accepted, and I'll touch back on that in just a second. If you don't have a power of attorney in place, your only option at that point for somebody to have the legal authority to stand in your shoes and make decisions on your behalf and execute documents, your option is to get a guardianship or conservatorship. And that process is not fun. It is lengthy. It costs time, money, and emotional expense for your family and loved ones. It can involve testimony, which isn't fun. And it's basically a relinquishment of your rights as an individual and can address things like voting and driving and all of that. So you really, in order to avoid that worst case scenario, it is really important to have that document in place. You can have one, but if you've done it in the last 20 years, but haven't updated it in the last 5, you really, really need to go see someone, talk to someone about updating it. Even if you don't have any changes to who's named in there, we have seen a lot of media address the fact that financial institutions can refuse those powers of attorney at anywhere between 2 to 5 years from the date of signature. So if you signed yours more than 5 years ago, just sign a new one. Banks face a lot of liability in honoring powers of attorney because they have so much power. And you could come in there and say, hey, I've done 5 since I signed that one. I don't have that person named anymore. The bank had no way of knowing that. But if all your money's gone, the bank's on the hook. So they are more likely to deny it if it is old. So just a tidbit.
Yeah, I exactly what you just said is was part of that experience with those clients that I had, and this was years ago. What I remember is that process cost them to get it granted cost about $16,000, and this was years ago. And this is a document that is very inexpensive by and large,
Mhm.
in terms of that. And so, and the story ended well. He had a full recovery for the most part. You wouldn't have known it if you didn't know it. They went on and they had the means to do it, but $16,000 or plus is $16,000 or plus. And so I try to, this is experiences that I've had that, when I'm doing these one-on-one meetings with these participants and people that are on this call, I ask them these questions because, man, you only have to witness it or go through it like once, and then you're like, heightened to the sensitivity of what it. And then lastly, and you don't have to get, I think everybody understands what a healthcare surrogate is and a HIPAA authorization. That includes also is that end of life care, or is that the living will part?
So that's a great question too. So a lot of attorneys will have legal forms that they prepare, and those can be 3 to 5 different documents. You can have a DNR, you can have a living will, you can have advanced directives, healthcare surrogate nomination, and HIPAA. Um, I tend to tell clients if you don't have one in place, what I usually use is the state health department form.
Okay.
You don't necessarily have to have an attorney draft that for you because you can go to your state health department website and you will find an advance directive that is legally authorized to use in your state. You can fill out the form, and honestly, I prefer to use those because I know that doctors, that's what they see all day, every day. It's
Yep.
been approved by the legal department. If I draft up some fancy lingo documents, they're
Good.
going to have to take them over to legal, and we don't have time for that when you're making these decisions. So I usually tell clients, hey, don't spare the expense, and you can go ahead and get them done today if you want to.
Yeah, that's great advice. Mine says if 2 out of 3 doctors declare me legally brain dead, they can unplug me, and I'm good with that.
Yeah.
And a lot of people on the call, just so you have a frame of reference, most everybody on this call, there are a few people that are under, but most of them are 55 and up, and a lot of them, a lot of this came abs and laws changed because of it. And I'm sure you studied it, but everybody on the call remembers the case in Florida involving Terry Schiavo and which became really shaped and changed how all of this went for in a lot of different states. Not everyone. I just know how powerful that was, and everybody on the call remembers that because it was like a soap opera almost every day. It was almost as big as O.J. Simpson and that whole thing. But
Yeah.
so, anyways, well, that's really good. Anything else on living wills and those kind of things before we move on to the below the ground stuff?
No, I do tend to tell clients when you're filling out those forms, sometimes they ask for things about organ donation. So it's important to be mindful of whether or not you have it on your license, because if it's on your license, you've already made a contract with the state for that. So if you've changed your opinion about it and you make that clear on your healthcare directives, you need to also make that change with the DMV too.
Perfect. That's a great point. Wouldn't have ever thought of that one. Okay, so let's talk about things that you're going to need as the basics and get into it once you pass away.
So there's really 2 things that you can have, and that's either a will-based plan or a revocable trust-based plan. You can have lots of other types of advanced planning, but typically those are not going to handle the assets that you own when you pass away. So you can own title to assets in any one of a number of different ways. You can own them individually, you can own them jointly. Usually that comes with rights of survivorship, but sometimes it's as tenants in common. You can own assets in a trust, or you can own assets in an entity like a business. And The latter two, the entities, the trusts, and the business, those have their own documents that say what happens when. And those take that interest that you own right now and it's handled outside of court purview. It avoids probate for the most part, as long as there are documents that say what happens. For the other entity ownerships, you have your individual, you have your joint ownership, you have your tenants in common. Joint ownership with right to survivorship passes immediately to whoever you have. And then your tenants in common, you own that 20, 30, 50%. So that is individual ownership. And unless you have a beneficiary designation, payable on death or transfer on death, otherwise POD or TOD, those ownerships interests that you have are going to go through your estate. And those are going to be governed by your will. And so many times when clients, even if they do revocable trust-based planning, which we'll touch on that, I'm sure, here in a second, but they're always going to have a will because there's going to be something that's out there, whether it's your car, whether it's a stock certificate or a bond your grandmother gave you, something's going to have just your name on it and it's not going to have a beneficiary. And we want to make sure that it gets to where it's supposed to go. And the only way to stand in your shoes and take that and put it where it's supposed to go is through your will.
So that's great. So if you let's go on the flip side. So there's reasons and what those things do, and obviously big reasons to have it. But let's say you don't have a will, then I guess that's the job of the probate court is to disperse those assets according to the laws of the state that are written by legislatures. But the judge is interpreting that law. And I say that because, he might see one thing one way, and I'm sure the lawyer arguing another way sees it differently, right? That's just the way a lot of our beautiful legal system works. But in a sense, if you don't do those things, then the state will decide it on your behalf, correct?
Yes, that is absolutely right. And I do put a little tiny asterisk
Yeah,
next to
sure.
all of this to say that can happen even with a will. And I've seen it happen with a will where clients say, I want my kids jointly to serve as co-executors. And I've had judges in certain counties because even though it's state law, depends on which judge you're in front of, and they can interpret that law differently. And some of them know how problematic it can be to have more than one person in that signing position. And I've had judges say, no, sorry, you just get to have one. So I do put that little asterisk of state law interpretation can even apply if you've got the document in place. So, but you're exactly right. When it comes to no estate plan at all, then you are literally going through and you're saying, okay, did they have a spouse? If they had a spouse, did they have kids? And every state is different. Some states say your spouse gets 2/3, your kids share a third. Some states say your spouse gets half and your kids split a half. I know in Kentucky, if you have a spouse, no kids, but your parents are living, the decedent's parents can end up owning assets with the decedent's wife, which
Wow.
just makes for some really awkward discussions. So no estate plan at all is absolutely governed by state law and is the vast majority of the time is not what clients would have ever wanted.
Yeah. Yeah, I would imagine so. I know it's not, you know, I know it's not the way my son's 19 and, I know exactly what he would do. He would, I mean, he would mourn me for a bit, but he'd go buy a sports car given the immediate opportunity of it.
Yeah.
So anyways, okay, couple of things. So you mentioned some of the advantages of it, but let's dive a little bit deeper. And this goes to that third question a little bit, everybody, in terms of trust planning. But really, what are the advantages of incorporating the trust planning as part of your estate plan? I mean, obviously, you mentioned that it has the ability, obviously, with proof and meeting certain criteria to have the assets in that trust bypass the probate process. But expand a little bit.
Absolutely. Not only does it help you avoid the probate process because a trust is a separate entity, it's not tied to your life. Uh, it is totally owned and controlled, and you benefit from it during your lifetime, but it is not something that has to go through probate when you pass. It keeps assets outside of probate, but not only in death, but also in life. So back to our earlier discussion about what documents can you have during life to help you prepare for incapacity should it occur. A trust is a great way to avoid that living probate that we talked about. I've seen powers of attorney get refused for being signed too long ago, but I've never seen a trust be refused. So that's a great way to avoid guardianship and conservatorship proceedings. When you pass away, not a lot of people know this, but probate is a public process. So when you die, your will is filed with your local county clerk's office, and that is public record. So anybody that wants to can go downtown and look and see what you've got and who it's going to and who you left out if you did. You also have to file an inventory. So not only do they get to see all that, they get to see what you had and how much it was worth. And some people aren't really fond of that. Um, probate probate is public, whereas revocable living trust process, that is private. So there's no judge or court oversight unless something goes awry. It is completely private and does not have to be recorded anywhere, what you had and who it's going to. It does allow for quicker access. In some states, it's super easy. When somebody passes away, as long as they get the death certificates fairly quickly, they can take the will down to the courthouse, and somebody can be appointed as the executor in a relatively short time frame. Sometimes it takes months, and it can require formal hearings. And it just really depends on where you are, who the judge is, what their docket looks like. But it's kind of a guessing game. And in that time frame, somebody's having to pay out of pocket for any expenses related to that. So like funeral costs, memorial service, those types of things, as well as utilities if there's real estate. And that's not something that everybody can always do. When you have a trust plan, you can have access immediately. Clients' children can call on the way home from the funeral and say, hey, we need to get this in place, and they can become the trustees, take it to the bank, and they can be on the account that same day. There's no appointment process, so to speak. Other benefits are you can reduce your costs and fees as well as your taxes. So probate, they charge a fee in order for you to go through that process. And that, again, varies by county. In South Carolina, it's based on the total assets in the estate, and it's a sliding scale. In some other states, it's just a flat fee, and it doesn't matter how much you got. They're just going to charge that flat fee. So there are costs and fees associated with probate that are not always reflected in trust administration if you're able to effectively avoid probate. If you have blended family or minor children or assets, especially real property in multiple states, those three things are really big red flags for me when planning for estates, because I want to make sure you have certain scenarios that trigger more expensive or time-consuming probate processes. So in those scenarios, typically we're looking at, okay, how can we best avoid having to go through a guardianship for your minor children? How can we avoid having probate going on in multiple states? And how can we make sure with the blended family scenario that we get everybody covered the way they were supposed to be and the way that you wanted them to
The way
be?
you wanted them. Yeah.
Yeah.
Yeah. Yeah. So just to unpack a little bit on that, and I can say this because I was a trustee for my late father's estate, be 3 years this next year. And I can tell you, the difference it makes having that advanced planning, Number one, you have a sense of what all is there if you do it correctly, right? There's no looking for stuff. Now, occasionally you miss something, and that happens. Like, especially if you accumulate assets over a lifetime, sometimes you forget a couple things, and I freely grant you that. But the nice thing about it is, like you said, I had immediate control. All I needed to show the bank was my certification of trust powers, basically a document that I got from the attorney, right? That just said what I can and can't do according to the rules of the trust. And then I think also it goes in that is that, whoever is, creating the trust for their beneficiaries, the trustee carries out the wishes, which meaning you can have rules to that. Correct. So you can dictate of when someone gets something outside of maybe some special circumstances. There's a lot of different ways you can do that, protect some of those things after your passing and those. So, yeah, that's really great. And that's so it goes back to the point of why I put that question on the thing, on the poll. Most people, and I think, our society, we adopt a lot of these terms, and sometimes they're meant to be derogatory. Trust fund baby, and specifically. And I always tell people all a trust does it, and you correct me if I'm wrong, it just transfers one asset from one person to the next in the most efficient way possible. And at the end of the day, wealthy people do utilize trust, but they're not for wealthy people. They are vehicles for everybody in a lot of different situations. Check with that. Any
Yes,
disagreements there?
none whatsoever. I tell clients when they sit down, because sometimes the documents look overwhelming, right?
Oh,
Because
yeah, yeah,
sometimes they can be a little bit longer. Um, it's just a contract. It's a contract between you and your property, and it says who's gonna manage it and how it's gonna be managed. And it's for everybody. If you
sure.
are concerned at all about ever becoming incapacitated, or if you have certain things that you want to make sure get where they're supposed to go, and you don't want somebody else making the decision about whether or not your wishes are valid, a trust is the way to go.
And then lastly, a couple things, just so everybody on the call knows, the vast majority of trusts that I see attorneys do for my clients, regardless of affluency or not, most of the time, the most common is that revocable living trust. What that simply means is that you can make changes while you're still living if you've created that trust. Once you pass away, those changes can't, the trustee can't go in and make changes himself. They you go, but so there's a distinction on revocable trust, meaning that you can revoke, you can change the assets in and out, you can change the rules of how you want that to be while you're still living. If you're the grantor, I guess, of that trust, if you're the person that created it, there are other type of trust, and that's what that fits a lot of different people. There's so many different types of trust. So, and we're not going to get in the weeds of all of them. The other one that a lot of people, I think, mistake for that is an irrevocable trust, which simply means, and correct me if I'm wrong, you can't change the terms of the trust once
That's
the
right.
trust is created. It's extremely difficult if you can even do it to begin with. And so most of the time, most of the planning that I see, I have seen the irrevocable trust too, but most of it is on the revocable side. But let's talk about a couple of other trusts because people on the call or listening might have that. There are other type of trusts that I think are worth, getting a foundational awareness of. So when they do meet with attorney, one of those is a Medicaid Asset Protection Trust. Really quickly, what is that?
That is a trust that you can place your assets into. There are certain time frames that have to be kept in mind when you're doing it. But you can place your assets into, you can still manage to benefit from some of the assets, but they are no longer considered yours for the purposes of benefits calculating Medicaid. And so if you become eligible for certain benefits, your assets that are in this trust are no longer considered yours when they're deciding whether or not your eligibility is valid.
Yeah,
Uh,
yeah. And,
yeah,
and I think today, it's a threat of increase. It seems like every year, but I think it's a 5-year look back. But I've seen legislation out there multiple times of going to 10. So just an easy one. Another one, and it never fails in doing this. I'll have someone follow up on this one, but a special needs trust. There are people on the call or listening or watching that undoubtedly have someone in their lives that a child or a sibling of someone that is going to be in need of special needs, whether that person be, whatever the situation may be.
Yeah.
Tell us about the beauty of that.
It's a great tool. So there's different kinds, and you may have heard it referred to as a supplemental needs or special needs. It depends on what state and what your benefits plan refers to it as. But it's a way that a third party can make contributions for the benefit of somebody who may be eligible for government benefits, and they are allowed to utilize and benefit from those assets, but they do not lose their eligibility for their government benefits. It can be done if the individual has assets already. But the best case scenario is when other people are gifting into it. And then you can avoid a state clawback of those assets when that person passes. So you can continue to leave those assets down to the next generation or to other beneficiaries without, at the end of the day, when the individual passes, having to turn those over to the state.
Yeah, and I think it's a really important one. I mean, you know, my wife and I are best friends. Have had a special needs son. Unfortunately, passed away a little over a year ago. But spending so much time with them and that family, and even have a cousin that's got a daughter that's special needs and will be in perpetuity as well. The number one fear of a mother and people like that is like, what happens when I die? Like, because like if, in a perfect world, we all outlive our children, right? And so that's the one thing that keeps people up at night. Like, man, how are we even going to deal with this? Because they're just so busy trying to keep up. So I've seen some amazingly good outcomes, and really just a weight lifted of that, like one extra stress. It's never going to be perfect, but the
Yeah.
ones that really keep people up, and I really, it's real important that you see and talk to someone about that. And the sooner, the better, I would guess on that. Anything less to add on that? I'm sure you've had circumstances with it.
No, it really is. It's a really neat tool. And you can have one set up and multiple people can gift into it. So if you have other family members who want to contribute, it's a great way for people to help. But absolutely, certainly, when a parent passes, I have seen that over and over again. How is their care going to be taken care of? Who's going
Sure.
to step into that role? And you can help monitor all of that through setting up a special needs trust.
Yeah, great. Any other trust before I kind of move on to a couple other questions, and we'll get into some question and answer here at the end. But any other questions or any other thing you want to bring up in regard broad trust and those kind of things that,
No, there are so many out there. There
yeah,
are life insurance trusts, there are retirement account trusts, there are gun trusts and land trusts and all those different types of things.
got all those.
And they serve really important purposes.
Yeah,
But it's really asset based and client goal based. So if you have any of those things and you've ever wondered, it doesn't just mean you have to meet a certain criteria
sure.
in order to have those types of plans put in place.
Okay. So, just a couple more questions here. How often should we, in financial planning, we're constantly looking at that because we have, moments like today where the market has, been a little turbulent as of late. And so, we always want to look and see how things hold up. That's why we do, financial planning. But how often should we review estate documents in that plan that we have?
The answer will vary. So I had another webinar recently where I was touching on this exact question. And I had gone to my trusty Chat GPT and said, hey, how often on average do major life events happen? And it said every 18 months, which I thought was kind of more
Ah,
frequent than I would have guessed.
me too.
I typically tell clients every 2 to 5 years. If you've gone 5 years without looking at it, it is well worth the investment that you made in putting it together to at least go back and have a quick look, have a little date night, sit there and talk about who's in what spot and what questions you have, what do you not understand. I would say state law, it varies on how frequently they update changes, but every 10 years, you're going to see some aspect, whether it's the Power of Attorney Act or the Trust Code, something changes every so often. So even if you don't have any personal changes, it's worth it to just ask and say, hey, does this still work the way that I want it to? Um, if you have a child who just turned 18, it's they need healthcare documents. You no longer are authorized to have access to their healthcare information, and you can't make healthcare decisions for them. Parents are shocked when their kids go to college and they're like, what do you mean I can't ask their doctor? If you move, jurisdictions change. We just touched on that earlier. Every state's laws are different. So you need to at least revisit your plan. It doesn't mean you have to change it in full, but just to know where those changes would be and whether or not those are important to you. If you get married, divorced, have a baby, those are all like big ones, right? Um, every 2 to 5 years, I would prefer every 1 to 3. 5 years is my max, um, because of the laws and the strategies that come up. Estate planning does seem like a very old area of law. It's been around for a really long time. And like I said, we got it from England. There's not a lot of major shifts, but every presidential election, there are changes in the tax code.
Yeah.
So every 4 years, it's a really good marker. And then major asset changes. If you have a business, if you retire, if you are shifting from liquid to illiquid assets, or if you're buying or selling property, those types of things, estate planning is a great way to incorporate your foundational plan into what assets you've either acquired or gotten rid of.
And the only other thing I might add on that too is that and she's mentioned a couple times, particularly early on the above the ground planning. If you had stuff in place and it's been longer than 6 years, I think it is. I know the laws in Kentucky changed within that time frame, and it might have been just so. If it's been six, in that lane, it is worth looking because I think every time it's something, not every time, but a lot of times when these changes come, there becomes a little bit more uniform, with other states in some ways. It modernizes, just like kind of, the interpretation of some of that. And so it's advantageous. It becomes more broad in the usage of it, from my understanding.
Yeah.
So if you had that, and then lastly, I would say, to everybody on this call, if you don't have this done, I'm going to take my glasses down and look over and I'm going to shake my finger at you and say it's time to act your age. Like seriously, like this is stuff that we really need. And just because, not only personal experiences that have shaped, but personal experiences with clients, it's incredibly important, guys. And I know that you want to say over what you have happened. Lastly, really quickly, what can people look for? What do they need to look for when they're trying to find an estate attorney?
So, my recommendation is there are a lot of really great attorneys out there. There are a lot of great attorneys who do a lot of different areas of law, and they're kind of what you would call your general practitioners, almost like your family doctor. Um, I may be very biased because I worked specifically in this area for a long time, but I think estate planning is specific enough that you want to have somebody who has a depth of experience in estate planning, who has some familiarity with tax law, because you can't have one without the other. You really need to ask them about their process. What does this look like for you? How do they bill? Estate planning is straightforward enough for the most part that most, if not all, can be done on a flat fee basis. But if they're going to do hourly, what does that hourly include? And what's their maintenance procedures? Are you going to reach out to me every 3 years, or do I have to pick up the phone because clients don't love calling their estate planning attorney? So if the estate planning attorney has a way of maintaining their clients, making sure their clients are aware of law changes and updates, that's a great thing. The
Great
other
point.
thing I would ask is, do they have multiple states under their belt? If the client needs multiple states. So if the client owns assets in another state and they can find an attorney who either is licensed in both, or if they can ask them, what are your resources for reaching out? Because I don't, as a client, I wouldn't want to hire you and then I have to also go hire and then be the go-between. Are you going to reach out to somebody else there? So I think that that's an important thing to keep in mind too.
Yeah, I think that's great. And I equate it to this. My father was a doctor. Disciplines matter. All attorneys go to law school, but all doctors go to medical school. But you don't go see a heart doctor if you need a knee surgery, and you don't, and vice versa.
Mhm.
You just don't. And I, the question I ask is, are you spending 90% of your time in this discipline or so? Are you making a living, in other words, being an attorney in this discipline? If there was ever one that matters, they all matter, but details really matter. And I've seen it both good and bad, unfortunately. And general practitioners they're smart, they're great, but if they don't live in the space, they can miss something. Just like if you're going to that knee doctor and you need, they know the whole body. They just, the specialty matters, and I think everybody understands that. So, okay, well, great. We're going to jump into the Q&A. Ramsey, hold there for just a second. Thanks, everybody. We'll be back in a week to kind of wrap this up with the foundations in retirement. We'll bring it all together. We got a little case study and some other stuff that we'll do in terms of that. Everybody on the live call, hang in place. I've got a couple of questions already in the queue. If you have more, let's go on and start putting those in there. But to those in watching this on the replay, feel free to share it with your colleagues, your friends, and your family at any time. We'll see you next time.